So we're live, but because we are in Romania, I should start in Romanian. So, bună ziua la o nouă sesiune drept ASE Webinars. De data aceasta, așa cum am și început în limba engleză, fiindcă avem un invitat din New York. O temă cu un titlu lung, dar foarte provocator. Și sperăm ca discuțiile de astăzi să incite participanți care pot adresa întrebări pe chatul YouTube. Le vom prelua, transmite invitațiilor și vom încerca să răspundem. Îi avem alături de noi pe Ionela Cucereanu, colega noastră de la Facultatea de Drept, pe Paul Cosmovici și Paul Llewellyn din New York. Colega mea va face prezentările și modera de asemenea sesiunea. Eu voi reveni la finalul acestea. Vă mulțumim pentru participare și sperăm să avem o dezbatere cât mai interesantă. Ionela?
Hello, everybody. Our dean was talking about the title. So yes, it's a long title, but when I chose the title, I had two things in mind. So we have legal protection of IP assets through the looking glass, a cross-border perspective. Why through the looking glass? Because if in Lewis Carroll's world, there is an imaginary world on the other side of the mirror, in my personal story and professional story, after graduation, I followed somehow the other side of life, of professional life, through the looking glass, and I discovered intellectual property. And the guide that guided me, the person that guided me in this new world, is one of our guests today, and I thank him very much. Is Paul Cosmovici, who is the founder of Cosmovici Intellectual Property, and also lawyer in the bars of Bucharest, New York, Paris, and Geneva, reputed specialist in the field of intellectual property. Why a cross-border perspective? To talk about the other side of the title, because today we have another guest that was extremely kind to accept my invitation, and he's Paul Llewellyn, partner at Arnold & Porter in New York, specialized in intellectual property, trademarks, copyright, etc. Two professionals, two IP practitioners that will help us see a bit through the IP world and discover some interesting perspectives, not only for initiated, but also for the students that maybe did not have anything to do with intellectual property. I thank you very much for coming today. And to begin, when we talk about intellectual property, I think the most common thing that comes in our minds, especially if we don't know very much about IP, is trademark. So trademarks are the first thing that makes us think of intellectual property. Why is a trademark necessary? Why do we need to protect a logo, slogan, something we create as a trademark? Maybe we're a small business, maybe we're a non-profit, maybe we're, I don't know, just somebody who tries to promote an idea, but why promoting it and why protecting it as a trademark? Who needs a trademark today? And I will ask Paul this question, Paul Llewellyn, to bring us a bit the US perspective, because, well, he's our guest, and let's see. How about US? Your microphone is muted.
There we go. Sorry.
Okay, there we go.
Every video call is a new adventure. Thank you for having me here, Ionela, and everyone. I appreciate it. your question is why, what are we protecting with trademarks and who needs a trademark? It's an interesting question because as some of your viewers may know, there are a couple of different types of intellectual property. In addition to trademarks, most obviously there are patents and copyrights. And a patent protects something like an invention, while a copyright protects something like creative expression, a book or a movie or a photograph or something like that. And the motivations for the reasons for that kind of protection is often stated as to provide some sort of incentive for creativity. So a patent owner gets a limited time to have the exclusive right to use their and sell their invention to give them an incentive to invent, right? So they're not going to make an invention and somebody takes it right away. And the same thing with the copyright owner, they have some incentive to create a work of art, for example, and know that they have the exclusive right to it for a while. Trademark law is a little different because a trademark is certainly, from the view of a business, an asset that they want to protect and have exclusive rights to. But the motivation largely behind trademark law, at least in the United States, is to protect consumers, is to protect from confusion. So it's a little bit more of a hybrid kind of interest and right, because it is clearly a valuable asset on the balance sheets of a lot of companies. And it's something that can be sold for a lot of money, but there is a strong public policy that permeates trademark law that says that the main purpose of it is to prevent consumers from being confused about the source of products or the source of services.
Sorry, I did the same. How about Europe? How about, let's say, because Paul Kosmovich is also, I was saying, in the Geneva bar. So how about Switzerland, not only the European Union?
Yes, thank you, Yanala. Yes, there are a number of differences in Europe, and you can consider European Union. I will discuss about European Union and about Switzerland. If you look at the US, where my colleague and friend Paul Lulin practices, they have very strict requirements. They are more sophisticated than we are in Europe. The only thing is that in Switzerland, for instance, you can lose your trademark if you don't use it for about 5 years. And the standard is quite difficult to understand. So there is no set of rules which can be anticipated. You have to really do business unless you lose your trademark. Now you have to think about Switzerland as being a federal state like the US, and they are very educated lawyers and judges. So you cannot trick them. So whether you use your trademark or you lose it. Now, considering the need of why protecting a trademark, we have to look at the history of Europe and of the trademarks. WIPO is source of a huge convention, and WIPO is based in Geneva. And then Paris conventions are again countries which understand very well brands. So it's in Romania, I know we usually ask, why should I have a trademark? In France, in Switzerland, in these countries like Germany, the first question is, how fast should I file my trademark? So this is the questions we find with our clients. And I think in Romania, we should simply align to what traditional businesses understand and traditional culture of business understands. Brand is your identity, it's you, and you have to make the market aware of your name first. That's very important. And second, if you start doing business like some companies do today in Romania without protecting their brands in the relevant markets, the cost to cover these and to cure all these elements is something like 1 to 50. You will pay 50 times the price you would pay to file and to register correctly a trademark. Yeah, so it's a question of market, of identity, of market culture, of business culture. I think this is a need to answer your question, Yana.
Paul was talking about the protection of consumers. Do you think that we have it here, like mentality, like we have a culture of consumers protection through the trademark? Or do you think that our lawmaker, when creating the law, thought of the consumers protection? or the perspective here is rather business oriented? We have the trademark to protect one undertaking from another.
Yes, you are very right. The concepts are very similar in the US and in Europe. So one of the functions of the trademark is to show a source of the good or of the service. And of course, this, first of all, it will serve the company to provide its services, its products, and then it will serve on the other side of the glass, the consumers. The question of the consumers is that trademark law considers them as sort of an average. Very often they are average people with low education. They are not all considered having graduate studies, university studies. So the level of confusion and very often the fact that consumers are tricked by brand owners is a reality. So indeed, trademark law would try and tend to protect all these consumers. The other side of the reality is that it's very hard for consumers to defend themselves. So it's a question of ethics very often. If you have a good business, a sound business, you will have nice trademarks and respect your consumers and other competitors' consumers. Otherwise, I think the theory is nice. Yes, they want to protect consumers. The law would like to do that. In practice, often we have all these tricky uses and similarities, and this is why you see so much counterfeit on the market in the online websites. They are possible because consumers are very often tricked. Yeah.
Mm-hmm. Take a bit of use it or lose it, because generally when we are not very familiar with trademarks, we may think, okay, I registered my trademark, I'm done. I may use it or not, but I have it there, like an asset, like some thesaurus, like I have it. Everything is all right. And here I will ask Paul Llewellyn, because we know that US has a slightly different approach regarding use. I would say a stricter approach regarding the use of the trademarks. What's the rationale? How does it work? Why a trademark owner has to file that proof of use of a trademark to the office, the intellectual property office?
So that's a very interesting question, and it does raise a lot of issues. And it's actually closely related to what I was saying earlier about how trademarks are a little bit different than patents and copyrights, in the sense that the focus is on the consumer and on the marketplace. And let me explain that a little bit. You can get a copyright or you can get a trademark registration issued, and you can just put it in a drawer in your desk and you own it. And you don't have to use it, you don't have to do anything with it, and you own it for the term of the patent or the term of the copyright, which in the United States seems to be infinite because the Congress keeps extending copyright protection so that they can protect certain very popular and famous characters in the movies. But with a trademark, you can't just take a trademark registration and put it in a drawer and not use it, because the purpose of the trademark, again, is to identify the source of goods and to protect against consumer confusion. And it's not what we call it's not a right in gross. We just don't have a right to a mark. We have a right to a mark to the extent we're using it on particular goods or services. So in the United States, there's two interesting points that I think contrast with most of the rest of the world. Number one is generally you need use of your mark in connection with your specified goods or services in order to even get a registration. So you can apply based on an intent to use, but in order to get that registration to issue, you actually have to prove that you're using the mark in commerce in the United States in connection with the covered goods or services. And the only exception to that is if you get a registration in the US based on foreign rights through the Paris Convention or the Madrid Protocol, which is for those of you who don't know, is a couple of international treaty systems that allow you to extend your protection from one country to another, your trademark protection. But even then, within 3 years, you have to prove use, or your international registration is subject to attack in the US. So that's one key issue. And the other is, and it bewilders a lot of non-US lawyers, I think, including trademark lawyers, is the idea that you can have rights even without getting a trademark registration. You can get common law rights in the US simply by using your mark in commerce without filing an application anywhere, you get rights. And those are rights that I could take into federal court in the United States and sue somebody else for infringement. If I can say I started using before they started using, and even without a registration, you could stop somebody. So use becomes a very, very important aspect of US trademark law in particular for those two reasons.
Okay. I admit that I asked this particularly because personally, I had an interest in the issues ever since the McDonald's, the Big Mac decisions of the European Intellectual Property Office. And for those of you that don't know, of course, of McDonald's, everybody has heard of McDonald's, and Big Mac sounds familiar, but it looks like for the European Intellectual Property Office, Big Mac was not used enough because McDonald's failed to file sufficient proof of use, and in a dispute with a competitor, the competitor said, no, you didn't file enough proof of use, so you don't deserve, when I say, to keep the trademark. And McDonald's has lost the case in front of the European Intellectual Property Office. And it may seem shocking because it's Big Mac. I mean, if not McDonald's, then who? So what's the point here? It seems that they use the trademark. What do you think? Can it be just a formal slip of the...
Are you asking me? I did read that. I'll just briefly say I did read that decision when it came down in Europe. And it was as surprising to me as it was to you. And I have to wonder whether it was just a technical issue of the lawyers not putting in the sufficient paperwork versus sufficient evidence of use versus some other issue. But it was kind of mind-boggling to me. It's McDonald's.
Exactly. Paul Kosmovich, you're also a new practitioner. So what's your opinion? What do you think? Technical error of the lawyers or?
Well, assuming that, I don't know, maybe 50% of the population cannot afford $5 Big Mac or $7 Big Mac, then yes, it can be understood. I'm not sure if they did some quantitative, but the price of a Big Mac, it's affordable for anyone. So yes, it's a strange decision. Normally Big Mac should be, even kids of age 5 or 7 know about and can order a Big Mac on their smartphone. So it's not a problem to, for me, it's a strange decision. Maybe it's a cultural way of trying to stop US, I don't know. This is my psychological analysis. Maybe they try to stop some US expansion or open the Pandora box for some other requests. Maybe this is one of the reasons why it's more a policy and business control by the state decision than a true trademark decision. I think also it's unfair.
Okay. And so we have our trademark registered. We have used it. We have used it very much. We're a very successful brand. We're Adidas, we're Xerox, we're, I don't know, Pfizer. And can a trademark be used too much? Is there a danger in becoming too popular? Is there a risk of being extremely popular, at least, let's say, in Europe? Paul Kosmovich, what do you think?
Yes. In Europe, at least, I don't know how it works in the US, but in Europe, if you find your trademark, I give an example, Xerox, yes, or we have clients that are called Payas, they sell bread, and in some countries in Europe, it became a very famous bread. But now people consider it a sort of type of bread, and then the brand, if it's really used without an awareness that it's a brand, it falls in the public domain somehow, to put it like that. So you can lose your trademark. And what
I think.
What we do, we try to survey the press in Europe, define it as a generic term, and then we try to notify these newspapers in several countries explaining, hey, it's a trademark. And then it's really a question of managing the portfolio of a certain trademark in many countries in order to keep the market aware. Hey guys, it's a registered trademark. You have an R on it, and you notify big players in order to stop using it in a generic manner. And yes, this would be a true danger. And then if the brand is a little bit descriptive, also your danger. So you try to capture most of the generic terms, bready, I don't know, like there are Nutella or other brands. You try to capture the market, and in fact you advertise for potential competitors who will use similar brands, but they are of course more or less generic. So yes, this is danger you have at the root of the trademark. When you file it, when you think about a new brand and you are too generic at the beginning, then of course using it a lot will help competitors.
Can this happen in the US also? Can you lose the trademark, the rights to the trademark by becoming overpopular?
Yes, certainly. It's very similar. And just to step back a bit, there's a basic rule in trademark law that I think applies in most jurisdictions, that a word that's generic can't be protected as a trademark. So I can't protect the word apple as a trademark for the fruit, the apple that you eat. But if the word is arbitrary, so it has nothing to do with the goods, then you can protect it. So I can protect apple as a trademark for computers because it doesn't have anything to do with computers. And then there's a lot of gray area in between those two. And then at the extreme end, there's the made up words like Xerox that Paul mentioned, or Google, or some other of the strongest marks you can think of. In even a very strong mark that's made up, for example, could become generic if it becomes the common word for the thing rather than
just Google it, for example.
Well, that's an interesting thing, though. In the old days, people would say never use your word in a way, never use your trademark in a way that doesn't sound like a brand. So we would always say don't use it as a verb and don't use it as a noun. It's an adjective. So it's Google search engine, or Google this or Google that. But once a mark becomes so popular that, like Google, so well known, I think there's room for a little bit of sloppiness in the way you use it, and there's I think a good argument that it's still protectable. But the old rule is always to be very careful about how you use your mark, to make sure you always use it in a proper trademark manner so that it doesn't become generic. And as Paul said, it's common for companies to remind everybody. Xerox in the United States, the copy company, the photocopy machine company, used to advertise. They would say, you can't make a Xerox copy on anything but a Xerox copier. They would actually pay for print advertising in magazines to get that point out to the public. And other companies have done the same. And there was all the trademark lawyers have seen this, but a few years ago, there was a very funny video that the legal department at Velcro company did to remind everybody that Velcro is not a generic term, but is a brand name. So it was like the general counsel of Velcro singing a song about how Velcro is a brand name. So it's a serious issue for brands.
One of our participants on the chat asks us is there a higher risk of counterfeit in case of the very well-known trademarks? What do you think?
I will let Paul here because Paul from New York, because the US has a concept of trademark, a TM, and this is very important to understand. I don't know it well, so please, Paul, if you would like to jump in, would be great.
So the question, Ionela, is there a higher risk of counterfeiting if it's a very well-known mark?
Yes.
I think so, because I think the more popular a brand is and the more widely known and purchased the brand is, it's going to attract bad actors and who try to make counterfeit goods. So it is certainly that's probably true. And some of the best known brands are the ones that have the most, you see having the most counterfeit enforcement programs, like a lot of the luxury handbag brands, the pharmaceutical companies who have very well-known brands, work very hard to stop counterfeiting. So I think that's the case.
Well, one may think that counterfeit has started, because it brought me that in mind, has started with IP. But in fact, counterfeit is as old as the Roman Empire, because in the Roman Empire, there were those merchants that were selling furniture, and to cover some defects of the furniture, some problems of the furniture, they were using wax. So that wax, in Latin, cera, cere, that wax, when the buyer was taking the piece of furniture into his house and it was warm, the wax was going out, so the defects were showing. And some of the merchants who were trying to market themselves as honest were marketing as furniture sine cere, namely without wax. So now we have this word sincere that we have it in very many languages, and this word comes from that, from without wax, so from a branding, from anti-counterfeit, I say, a branding manner. Counterfeit and let's say cheating a bit in advertising is rather old, not appear with intellectual property law. Okay, another question we don't have for the moment. So if we don't have another question for the moment, I will try to go a bit in the patent area. And in the patent area, of course, it's a rather complex field, and for our students that are not very well familiarized with intellectual property, it may be a bit difficult. But in the patent area, I think about one issue. Recently, we had this problem. If an artificial intelligence form can be recognized as inventor of a patent, the European court said no, definitely. And I think I've read that in the US, correct me if I'm wrong, there were also some cases that denied intellectual property rights to artificial intelligence. What is your opinion about that? How do you see these things? Is it absolutely impossible for AI to become owner of intellectual property rights? Let's see the US perspective first.
Thank you. It's a very interesting question, and I think to pick up on what Paul said earlier, this is a real Pandora's box, because the implications of this go far beyond intellectual property. But here's the situation in the US. The United States Patent and Trademark Office a few years ago, they issued a commentary or rule that says that a AI cannot be the inventor of a patent. And this is they base this on the statutory language in the US, and the US patent law refers to an inventor. It says whoever invents or discovers any new or useful process, machine, manufacture, or composition of matter may obtain a patent. So they looked at that word whoever, and they looked at some other references to inventors in the statute, and they said this clearly is talking about a person and not anything else but a natural person. And in fact, in US law, even a corporation can't be the inventor of a patent. The corporation can get the patent assigned to it after its employee invents the patent, but the corporation can't be named as the inventor. So the USPTO said the inventor has to be human. And so somebody challenged that. And I think it's the same person that challenged it in the EU. It's a law professor. I can't remember what law school he's at. But they filed a couple of patent applications in the US, and the patent office rejected them. And so they appealed that to the federal court. And the lower level federal court just heard argument on this last month on April 6th, and the judge was very, very skeptical of the idea that an AI could own a patent, could be the inventor of a patent. And based on the statutory language, that the statute sounds like it means a person. In the arguments, the issue is this in patent law: if the AI is not the inventor of the patent, then of an invention, then who is the inventor, and can it be protected by patent? So an example of where this is very relevant is, for example, with pharmaceutical drug discovery. So the pharmaceutical companies are all developing AI that can very rapidly examine many different potential chemical formulations and chemical compounds and try to figure out what those chemical compounds might do in a practical application. And so it's sort of like the AI gets programmed and coded by human beings, but then the AI goes off and tries to figure out what might work, like try to invent a new drug. And so if a company uses that kind of technology, and if the AI can't be the inventor, it's not clear that the humans are involved enough to be the inventors. So then you have a risk that you have an invention that can't be patented, and then it can't be protected. And that incentive I talked about earlier in patent law to incentivize invention does not exist. And so it raises very practical questions for businesses. But on the other hand, how does this work? If you say, yeah, an AI can be an inventor, does that mean an AI can sue somebody for patent infringement? Who decides? Who does the person that owns the AI get to stand in the shoes of the AI to assert that kind of claim? Or are they more like a trustee with a beneficiary, the way you would with a child? It's very unclear what the implications of all of this are. And it reminds me of a case a few years ago that's a very similar issue, where a lot of you may have heard of this, where a monkey took some selfies, and the question was, can the monkey own the copyright in the selfies? And again, that opens up all these issues of who has standing to sue in court, who has standing to own property, and the implications of that are so far-reaching that I think it has to be something that's thought about on a very comprehensive basis, and not on this narrow issue of, can AI be an inventor?
Okay. What do you think, Paul?
It's very hard to add something to what Paul said. I thank you so much, Paul, for this insight. We are asked by clients, but it's rather a theoretical question. I think we are too early. Today it's a revolution in the IT, and the society is not yet ready and united in a way to say, okay, we would like to have this sort of invention done by an AI, by a software, in fact, because the owner of the rights should be this entity or this person, or maybe a machine. And deciding that the machine can have rights and decide on suing, as Paul said, etc., is a whole change in the legal system, which we have since Romans and since, I don't know, very, very old, very established law systems. We cannot change that just by saying, hey, we have a formula, we have to do something. No, you should change completely the system of law, which is not something to do now. It takes maybe hundreds of years. What I see now is that you can today try to consider it a sort of know-how of the company, and all the employees using algorithms and developing all that should normally be somehow owners of all that's discovered eventually by AI. I would not file patents. I would not spend too much time on that. But of course, it's a huge patent. It's a huge business behind. So maybe it's a question of a limited number of years until courts will start having courage. I would love to see that in the US, having the courage to say, yes, this formula or this AI result belongs to whom? We wait for that decision in order to be able to then follow a sort of path. And I think overall, we will have a sort of very isolated niche of AI world. being able to be attributed to some, it's out of discussion to file a machine created algorithm as a patent application. And you need, like in the US, are the same concepts, the same congresses and corporate treaties. We need an inventor, a human. It's a sort of nostalgia to have robots, but no, it doesn't work, at least today. Yeah.
Regarding the filing system, to make a comparison, when you file a trademark, it's rather simple. You file a form and things go smoothly or not. But when you file a patent, US has a rather different system, and I would say that's more beneficial to the inventor, because you may have an idea and you may not have all the elements to draft the patent claims. So on the one hand, you would like to protect your idea and have it registered as a patent, or at least filed for registration. On the other hand, there is a high risk if you don't have all the elements in mind or everything very well, very clear cut, you might lose your registration request might be dismissed by the office. And the US has that system of the provisional patent. So why a provisional patent? It's something beneficial to the inventor? Is there a risk? I see it as something very beneficial to the inventor and something that comes to help the inventor that has a little bit of time to think more about the invention. But how does it work exactly? And is there any risk? Is there any shortcoming of filing a provisional patent and not a regular one?
I think that's a good question. I think it certainly is beneficial to the inventor. It's not quite analogous to the idea with the trademark application I mentioned earlier of an intent to use application. But the idea is with the provisional patent application is that you get something on file, so you secure your filing date without having to go into the detailed specifications and claims that you would have to do in a full patent application, which can be very nuanced and very complicated and require a lot of attorney time, frankly. So the idea is you can get something very simple on file. And the benefit, like I said, is you get your filing date earlier. In the only risk of it is that you need to make sure that you have enough detail in there that it sticks, that it is found later on. It's found to be sufficient to describe what your invention is, because there's a risk that you put something in that's too simple and you rely on that date. But then it turns out later on that a court or the patent office decides that you weren't sufficiently specific, and then somebody else managed to come in and get priority. So there's some risks, but it is certainly a helpful tool in many circumstances.
Okay. Talking about patents, I see we have here a very specific question regarding the situation with the pandemic. So one of our participants asks, why are vaccines patented? And shouldn't it be available to everyone? So a discussion, a rather challenging question, but well, what do you think? Well, the traditional answer, I guess it's their medicines or something like that, so we have to patent, but how do you answer our students? Who wants to take the floor?
Okay, I'll jump into the fray. This is very much a policy question, right? I think, and not a legal question, because the legal answer is simple. The patent law in the US and most other countries gives the inventor of the patent the exclusive rights for a certain period of time. In the US, it's 20 years. that's an easy answer. The policy answer is a much more complicated thing. Like I said, the policy behind patent law is to incentivize the inventor, because and certainly in the area of vaccine development or drug development, there's a tremendous amount of money that has to be invested. Oftentimes, the investment doesn't pay off. And the motivation is that if you invent something good, useful, you will have exclusivity for it. But there's certainly a political question about whether at this time of COVID and where we have this worldwide pandemic, whether there's a policy reason to alter those rules. I can certainly see the argument on both sides of that issue. I won't take a position.
Okay. Paul?
Yes, for me, the question is difficult, but in fact, we have other similar situations where you could say, hey, we would like to have this patent free. And it's almost impossible to convince a state to do the job that these companies would do. And very correctly, Paul said a lot of money is invested. The state would not have the resources, would not have human resources, and not enough money to perform this so quickly. So this is one reason why they should allow the patents. And then, of course, there are some exceptions in the patent laws where you can a state can decide to use without giving fair compensation to the patent owners, but they could, in some cases, use the patent, developing its own products based on this patent, giving some money back to the patent owners. Still, the patent will not be nationalized, like real estate could be at some point. So I think it's better. This system is much better. It creates a sort of fear, maybe, but can you be more, have a more quiet situation when a state owns and controls everything? There is no more competition. We had this in Romania. I'm not sure it's always a good idea.
Yes, exactly. Thank you very much. And now another question that comes not from the patent law, nor from the patent, neither from trademarks. Considering the online classes we are attending, how can we know if a book, for example, is given to us legally on the different platforms we are using? So copyright in the academic system. And given the fact that, let's face it, there are so many websites, archive.org, and where you can download books that are subject to copyright. What about copyright? What about this question? Can we know for sure if a book is legally provided by a website, download, or Olin? What do you say?
I'm not sure you can ever really know. It's a complicated issue, and even for companies that are publishing materials, there's often a whole team of people. If you're on a television production or something like that, there's a team of people who are just trying to clear copyright, because it's so figuring out who actually owns the copyright, who was the author, who owns the copyright, was it assigned to someone else, where are the rights held, who is authorized to give permission, it can be very burdensome and very challenging process. So for an end user, like a student who is just finding a book online, it's hard to say if you can ever truly know that it's legitimate. It helps if there's certain indicia of legitimacy on the website. If it says that if they're claiming that their use is under license or something like that, that might give me a little more comfort. I have I spent a career practicing intellectual property law in representing rights owners generally. So I have when it comes to something like downloading online pirated music or videos or movies or something, I have a inherent resistance to that, which my teenage daughter never could understand. But I do have this sense that you can often tell this kind of website doesn't look like it's a website that's legitimate or that has authorization. And then you can kind of tell the ones who generally do have authorization. And at the end of the day, most of the time, if you're an end user who's acting in good faith, you're probably not going to get in trouble with a copyright owner.
You know what's funny? There are so many intellectual property books on these online platforms. It's amazing. I know it from a friend. Okay.
Yeah. And what we do also, I'm not sure how it works, how it will work with this new law faculty at ACE. I'm very happy to see that. There are some databases, huge databases, where universities worldwide have access to millions of resources. So in case the law school is able to pay this sort of membership and to offer to the students access to these platforms, they will definitely access a lot of material for research, which is cleared somehow. It's cleared and it's assumed by the university system and network. Now, also, of course, you can look at the publishing company and ask if you really want to use important parts of this material. And then you take a risk, as Paul said, is very well said. You need a sort of good faith check of the website where you take it from. If it's just a list of references, have it here, guys, it's a nice material I send you. Or if you find the same material with $60, $50 on some websites, and then a lot of free material on other websites, the same material, there might be an issue. You can also check for terms and conditions on the website where you try to download to see if they assume some sort of responsibility and if they are based somewhere like in a civilized country, Western Europe, US. I don't know, I can give many examples of civilized countries, but it's a due diligence you have to do a little bit, especially if you want to use extensive parts of this material. Yeah, this would be also my short answer.
Thank you. Let's get a bit to designs, because when I started working in IP, it seemed rather simple. Designs are similar to trademarks, but not very similar, but similar. After a period of time, I began to think that designs, from one point of view at least, are rather similar to patents in terms of filing, etc. So I would ask you, what can be protected as a design in Europe and US? And what's the difference between filing a design and filing a trademark? Why isn't quite the same thing? Because the visual would make you think that, well, it's a similar process. What's the difference? Why having a design? Why not registering, if it's a picture, let's say, why not registering it as a trademark? Paul Llewellyn, US?
Thank you. That's a good question. And design law is, I think, very different from country to country. And in the US, the kind of protection you can get for a design, for example, I think we're talking about a product design, for example, the shape of a product. It varies depending on, it's different depending on what kind of rights are being protected. So in the US, there's a thing called a design patent, which you apply for just like you apply for a regular utility patent, but the design patent covers only the ornamental design of a useful object. So it could be just the ornamental shape of the iPhone, for example, was protected by a design patent. Or I had a litigation once that involved the shape of a coffee maker, like a drip coffee maker, so household appliances. Sometimes the shape of a sneaker, of a athletic shoe might be protected, all sorts of things. And that's called a patent. And all you need to do is show that it's just like with any patent, you have to show that it's a new, it's a new design, but it's only for the ornamental aspect. So it becomes a design patent. That same exact design you can apply for as a trademark, but under trademark law in the United States, for protection of product shape as a trademark, you need to show acquired distinctiveness. So you need to show, we've used this for a long time. We've advertised the shape, and people have come to understand that this is source identifying, that it's a trademark. And then the other thing to think about is whether you can get copyright protection for the configuration of a product. And there it's much more difficult in the United States. You can certainly get protection for us. If I make a sculpture, right, you know, just a sculpture of a person, that, for example, that's a sculpture, that's an artistic work, that's protectable in copyright. If I make the shape of a coffee maker, that's a useful article, and you can't get copyright in the shape of a useful article. What if I make a sculpture of a person and then I put a lamp on top of it, right? So, or a fish, whatever. I think that's what the case was. There was a case where somebody had a sculpture of some animal or something with the light coming out of the top of it. And they said, well, that's separable conceptually, the sculptural part from the useful article. So that's protectable. So it really depends on the particular design in the copyright area. But at the end of the day, it depends on what type of rights you're trying to protect with the design.
Thank you. What about Europe?
Yes, in Europe, the discussion is somehow at a lower level of sophistication, let's say like that, like perfumes. In fact, in Europe, it's a very cheap system. They encourage filing European designs. It's done in Alicante, and you cover 27 member states with a tax of 350 euros, which is very cheap. There is no real examination on the novelty of the design, so they rather let other the design owners to oppose, to attack. And we use designs because this is the question: why using a trademark and a design? We use both. One of the reasons is because we can protect easier protect the borders in Europe. Police customs understand very easily certificates, and we have a nice certificate for a design. The difference with trademark being the classes. In trademark law, you need to specify a class. I want to do watches, I'm in class whatever. I want to do jewels, etc. If I'm in chocolate industry, I need class 30. Whereas for designs, you can file, for instance, for logos and shapes. And then wherever you find your design, it can be on a car, it can be on a dress, then you can try to stop. And normally police customers will understand that. It's a wonderful, cheap tool. It takes less than a trademark to register. There are a number of other reasons when you have difficulty with a trademark. Is not such a strong trademark, or the visual of the brand is so important for you that you would like to have the design. It will be a 2D, two-dimension, just a picture of a product. Then you will file this as a design instead of as a trademark. Maybe the trademark will not be a tool. And often it's a question of strategy. You have several products, several lines of products, and then you say, okay, for these ones, I need trademarks. For these others, like packaging, I will try to use designs. And it increases the value of the company, of course. If you look for investors, having more assets, being able to show more IP in the company could bring a much nicer value of the company at the end of the day. These are some of the reasons to do one or the other or both.
Mm-hmm. Okay, thank you. And let's say that I'm an IT specialist, which I'm not, but, and I create some software, some video game, I don't know. Can I register the layout as a design, or how do I acquire protection for my specific layout, for my visual interface?
In the US, you could get a visual interface on a smartphone, for example, or a website. You could, in theory, get protection, call it trade dress, and essentially that's a type of trademark. And you could try to get trademark protection. Again, you might be expected to show acquired distinctiveness. That means to show that you've used it for a long time. But you can also apply for a design patent for that appearance of the, for example, I think that Apple has a design patent protecting the appearance of the icons on the iPhone screen, sort of that basic layout of the main screen that you see. So there are a couple different approaches to trying to protect that as well.
Okay.
Yes, and I have a question for Paul also. How do you protect with copyright web layouts? Because we are able to do that in Europe, but we heard it's quite difficult in the US.
I think it would have to be a fairly distinctive layout to be protected by copyright, because the Copyright Office in the US is they can be fairly strict about the amount of originality and creativity that is required to get a copyright registration. So for example, a lot of times clients have a logo that they want to trademark, but they also want to protect in copyright. And the Copyright Office will say, if you just have a stylized version of your word mark of your brand name, it's not enough to get protected. And a lot of website screens are, so many websites are created from these sort of modular components, in these website building toolkits, and they all look the same. So I think you need to find a certain amount of creativity and originality that a typical website might not have. I mean, if you have original text and original images on the website, you could certainly protect those. But the arrangement, I think, is going to be, to try to protect just the arrangement of elements can be very difficult unless it's a really unique arrangement.
Okay.
Thank you.
Yeah.
Go ahead.
I was thinking, who said lawyers have boring lives? You see, creativity all over if you work in IP.
It's true. It's true. Just to add, for Europe, it's much easier, and we appreciate that. Of course, it's a question of creativity. How you explain to an employee of a copyright office, hey, this is very creative, I assure you. So in Europe, it's much easier. In Romania, we have the Copyright Office ORDA. In France, we have INPI, the French National Institute, and there we can file. We simply print layouts of the website, and we never had such application rejected. Whereas in the US, we would expect a rejection. So the standard of creativity in tech field, especially websites, is much lower in Europe, which is good for the European market to protect sort of automatic, like WordPress templates or other templates. You could do this with copyright also. And then, as Paul said very correctly, we have many examples in Europe of clients having these issues being copied. We try to protect element by element, the important elements as copyright. And then from there, we can start moving to the next level, which is unfair competition, trying to show there are some unfair competition practices based on the copyright and similarities, not necessarily on copyright.
Okay, thank you very much. I see we're running out of time. And as promised, we will keep it within an hour. We promised our students that it will be a very well invested hour. And for me, it certainly was. That's why I thank you again. And I was thinking that we managed, thanks to your help, to take a tour of intellectual property. And I really hope that our participants not only enjoyed it, but managed to acquire some information, or at least they are more curious about a field of law that maybe was not of a great interest for them. Because, every first-year student thinks of civil law, criminal law, and when he or she hears about intellectual property, it sounds a bit exotic. It may be exotic, but it's very practical. And I hope that our participants understood this, that it has a high degree of pragmatism also, but of creativity on the same time. Because I think that you can't work in the IP world if you don't have such passion for creativity. That's my opinion.
Thank you, Anela. Thank you, Paul, both Paul. I think we had today the chance to meet some of the best experts in intellectual property. In a way, to prepare our students, but Anela, I have to mention that these webinars are addressed to both students and practitioners. So we try actually to create a platform in which to let know the students on the new stuff there, but also have a debate with the experts in the field. And as Paul said earlier, we hope that our faculty, let's not forget that it's a faculty in the Bucharest University of Economic Studies, will be able to enrich this area and have specialized studies in intellectual property. Thank you all for your participation. It was a very interesting. We're already receiving messages that they liked it. So if you're open, we'll actually reschedule maybe in the autumn anyway, and preparing like this for the official course that will come in 1.5 years. Thank you all.